everybody. My name is Jordan Walker. It is noon, so we are going to go ahead and get started. Thank you for joining me today for our presentation on eminent domain in the state of Indiana. Again, my name is Jordan Walker. I'm with the law firm of Seaver Walker Paget, and we are going to go ahead and get started. Let me share my screen real quick. And we'll go ahead and get into it. So real quick, I want to get some preliminary information out of the way, some questions you might have. Why did you get a letter from our firm? You might be asking yourself that question. And the reason you got a letter from our firm is because we try to monitor these road projects in many states, including our home state of Indiana, of course. And according to our research, your property lies adjacent to a project that they've already begun some land acquisition. So in other words, we looked into all the road projects going across the state of Indiana, and we found that at least some of the parcels on the project that is affecting your property have already been acquired by INDOT or by another governmental agency. And so what that tells us is if they've already begun land acquisition on other parts of the project, that tells us that at some point in the future, they're going to come to you to try to get your property. And so that's why you got the letter. That's why we sent it at this time. A real quick introduction again about our firm. We do not work for INDOT. We do not work for the state of Indiana. We don't work for any cities or condemners or entities that can take land. We are landowner attorneys only. We only represent landowners. We have never represented a condemner, and we have no plans to. So we are eminent domain attorneys, landowner eminent domain attorneys only. This is the only type of law that we do. We have no other clients of any other type of law. And as a consequence, because this is the only thing we focus on, we've learned quite a bit. We've learned quite a bit, not only in the state of Indiana, but across the country, as we do operate in different states, but our headquarters is located in Carmel, Indiana. So we are Hoosiers, of course, but we've learned quite a bit about eminent domain. And today we're here to kind of share what we've learned so that you're prepared when they come through and start making offers for your property. So if you don't have an offer, that's fine. Our research indicates at some point in the future you will receive one. So our goal today is to prepare you for when that acquisition starts so you know what to do. What is eminent domain? A question we get a lot. Eminent domain is the forced acquisition of private property for a public use or public purpose, meaning in this instance, it's INDOT or it's a county or it's a city. They have the ability to take your land and put it to a public use. So they have the ability to do it. They have the ability to take your land, but they still have to pay for it. So they can take it, but the check on that power is that they have to provide just compensation. And just compensation can mean a lot of things, but ultimately is what are you entitled to for the acquisition of your property? Money. What amount of money are you entitled to because of the acquisition on your land? And that's really the long and short of eminent domain, is that they can take it and they can put it to a public use. And the most common public use you'll see, of course, is a road. But there are other type of public uses, schools, utility lines, railroads, you name it. These all serve public uses, and they can form the basis for an eminent domain acquisition. But for this purpose, we're talking about roads. So because the condemner has the inherent ability to acquire property, it is very difficult to challenge these acquisitions, meaning stop them. Stopping takings is very difficult. We've done it before, and I'm sure we'll do it again, but they are very fact-specific inquiries to whether or not you have a case to fight the taking. It has to be, usually it would have to involve some sort of fraud on behalf of the state of Indiana. They're lying to you about something. But by and large, they can take it. It's very difficult to stop these takings. So I tell folks generally to focus on the compensation aspect of it, because that's a much more even fight. And so that brings us to the next slide. What is the eminent domain process in the state of Indiana? Each state has its own unique pre-condemnation and condemnation process. And when I say condemnation, condemnation effectively means eminent domain. Condemnation is the type of lawsuit that is filed against you, and we'll get into that here in a bit. But condemnation is basically the procedure for eminent domain. You can think of it as if it's the same as eminent domain. They're synonymous effectively. So the acquisition process, the requirements, the procedure in Indiana is as follows. The first step in the process is the appraisal. The state of Indiana, INDOT, whoever's acquiring the land, they will come out and appraise your property. An appraiser will appraise the property. And then you will get an offer based off that appraisal. So the appraiser comes out, they appraise your property, they go back to INDOT, they give their appraisal to the right-of-way negotiator that works for INDOT or the state of Indiana or whoever's acquiring your land. And then they come back out and they issue an offer that's based off that appraisal. And sometimes there are negotiations at this point of the process. A lot of times the state of Indiana and INDOT and other condemners adopt a hardline position and basically do a take it or leave it scenario. It really depends on who you're dealing with. And sometimes there are negotiations, but a lot of times there aren't. And they basically say, this is it, deal with it. But either one way or the other, that's generally when our firm gets involved, when an offer's been issued and you have a case that can be analyzed and we can look at it and see if it's something that we're interested in taking on. But once you have an offer, that's when our firm gets involved. And if you do have an offer and you're interested in getting it for your review, we're more than happy to provide that. You just have to send it over. So in any event, the appraisals have been done. You've been issued an offer. Let's say there are no negotiations and they aren't going to work with you at all. But you still don't want to take what they're offering. What happens next? Well, eventually they have to get the land, and they being INDOT, of course, or the county or the city, and they will file a petition for condemnation. This is the lawsuit. This is an eminent domain lawsuit. They'll file it in the county where the property is located. They will serve you, a process server will serve you with the lawsuit. And at that point, you are in an eminent domain litigation. And a lot of people ask me, is this good? Is eminent domain good? Is it bad? Because a lot of times right-of-way agents and condemners use it as kind of a cudgel or a hammer to scare folks into taking offers. And they'll use it kind of pejoratively and refer to eminent domain as a scary process. They'll say that you get nothing. They'll say that you're not entitled to any compensation at all if you go to eminent domain. And that's not true, of course, but it doesn't mean that they don't use it. So back to the original question, is eminent domain good? Is eminent domain bad? What I tell folks is that if you are in eminent domain, it should be because you want to be in eminent domain, meaning that's the only place that you're going to get just compensation. What it means that the offer that they issued is so bad and they are not negotiating, but you're entitled to more money. In that instance, you should want to go to eminent domain because otherwise, in that scenario, you'd just be accepting what they're offering and not getting a full just compensation. So, on the flip side of that, you shouldn't be in eminent domain if you shouldn't be in eminent domain. And I know that sounds circuitous, but the point is, if you are at litigation in your case and your offer is not that bad, or maybe there's not a lot of upside there, or maybe it's even a decent offer that there's really not a lot of money there, then you're stuck in a tough spot because the lawsuit's been filed and now you got to pay attorneys, potentially pay experts to come in. It gets expensive quick. So what I'll say is that if you're in eminent domain, it should be because that's the only venue where you're going to get just compensation. And beyond that, it's worth it for you to invest in an eminent domain lawsuit to make sure you get your full recovery. So back to the process. The lawsuit's been filed. What happens next? A certain point, usually within 30 days of the petition being filed, but not always, the state of Indiana or the condemner will file a request to acquire the land. And in response, the court where the litigation is filed will appoint 3 appraisers that are supposed to be from the county where the property is located. These appraisers are, again, they are supposed to be independent appraisers. Again, they're appointed by the court. It isn't always the case that you get appraisers who aren't biased. A lot of appraisers do NDOT work, so it gets very difficult for courts to appoint folks that haven't already worked for NDOT or want to work for NDOT. So in any event, they will appoint 3 appraisers. The appraisers will come up with an appraisal report. They will determine preliminary just compensation, as I refer to it as, and they'll file a report with the court. And so basically the purpose of the court-appointed appraisers is to determine a preliminary just compensation amount that the state or the condemner must deposit with the court so that they can get access to the land. And the reason why they do that is basically to allow the state to get access to the property to begin the road project, and while the litigation continues on to a jury trial. So the court-appointed appraisers come up. Let's keep things simple. Let's say you were offered $5,000 pre-suit for your property, and you think you're entitled to $30,000, and can't come to a deal, can't agree. NDOT files their complaint, their petition for condemnation against you. They request access to the property, and they request that the court appoint appraisers to determine this preliminary compensation amount. The court does that. They appoint the 3 appraisers. They go out, they do their job, and they say you're entitled to $10,000, let's say. And so what happens then is that the state of Indiana or NDOT or whoever deposits that $10,000 with the court, and then in exchange for that $10,000 deposit, they access the property and begin work on the project. The case is not over at that point. If you disagree with that amount, that $10,000 amount, you need to file what's called an exception within 45 days of it being filed. If you don't file this exception within 45 days, the case is over, because that court-appointed appraiser amount effectively becomes the amount of money you get, the $10,000. So you need to disagree with that number if you do disagree with it. And then if you disagree, you file your exception within 45 days. The case proceeds on like any other litigation, eventually ending up, if it gets to that point, in a jury trial before jury members from the county where the property is located. That's a lot, I understand. I think it's important to understand that not every case reaches litigation, and not every case that reaches litigation reaches a jury trial. We have resolved cases at every stage between 1 and 5 on this process. We've settled pre-condemnation, we've settled post-offer, pre-offer sometimes. At any stage, a settlement can resolve. So I don't want to make it seem like just because this process exists that it's every single a case lasts every single lasts through every single step. So that's the process from beginning to end. I think it's important to remember that you don't necessarily have to memorize this process. If you have an attorney, if you contact an attorney when you get your offer, for example, you contact me or one of our associates at our firm and want to talk about your case, we can go over this process again. I can explain exactly what happens. It's not a problem. But just be aware that this is how the process works generally. Well, I should say it works. This is how it goes. This is the legal process, but it doesn't always reach each step, I should say. And with that being said, I want to talk about what to do when you start getting in negotiations with right-of-way agents, when you start receiving an offer. What to do when what's going to happen is somebody from the NDOT is going to reach out to you. They might call you, they might email you somehow, they might even knock on your door. But what I tell folks is that when they reach out and they say we want to give you an offer, they might just send it to you via certified mail. What I tell folks, first of all, insist that the right-of-way agent communicates via email only and sends you the offer packet via email in addition to regular mail. They might send it certified. Either way, the point is that you want to get it. It's easy if they send it electronically as well. And I tell folks to keep all communications with right-of-way agents via email or text. Verbal conversations will get you nowhere. You want to get them on the record if they start making offer. If they choose to negotiate with you and they make you an offer, you want that in writing. You want that in email so that you can keep that, and you can keep that for your back pocket and know that they're willing to at least give you some amount more than what's offered down the road. So I tell folks, insist that you get it via email. I also tell folks, give yourself a week to review the offer. You don't need to respond. They're going to make it seem like you need to respond. You don't need to respond. What I tell people is once you get the offer, tell the right-of-way agent via email. Again, don't call them. Say, thank you. I'll review this. I'll get back to you in a week. And then once you do that, you contact an attorney for review of the offer. You can contact me for review of that offer. And I'll review it, and then you can decide what you want to do. And it's an easy way to handle these cases. It gives you a little time, a little breathing room to respond. You're not pressed for a response, and you're also not leaving them in the lurch, and they understand that something's coming, whatever it might be. Again, avoid in-person discussions, avoid in-person negotiations. These are not helpful. You want any offer they make, they should make in writing. Here's what not to do when you receive your offer. Do not engage in negotiations or discuss value before you talk to an attorney. Obviously, you're free to negotiate. This is your property. You can do what you like, but you can always negotiate. You don't need to do it immediately. You can wait until you talk to somebody who understands what's compensable and what's not. And that's an important aspect of eminent domain is not everything is compensable. You don't just get money for things because you say they exist. There are accepted methods of valuation that courts will accept. There's accepted evidence of valuation that courts will accept. There's also stuff that is not acceptable. For example, you can't get business losses if you have a commercial property in the state of Indiana. That's just how it is. That's the law. But that's an example of something that you do not get. And the same thing applies to other properties. It's important to remember that the market determines the value of your property, and the most important evidence is market evidence. And a lot of folks get into things that are not compensable, and it gets them in trouble. So with that being said, I would not engage in negotiations, discuss value. You have plenty of time to do that. I would not do it without talking to somebody. Don't go out and get an appraisal. A lot of times, INDOT right-of-way agents will tell landowners, well, we have an appraisal. You go get one and we'll respond. First of all, they don't need to respect your appraisal. You can go out and get the best appraisal in the world in response to their appraisal, and they'll just say, we disagree, we have our own. And then you're stuck with an expensive appraisal that they're not respecting. Appraisers are usually necessary if you're at litigation. We generally don't get appraisals until you're at litigation. It's a cost that might be necessary, but we don't like to incur it on our client's behalf unless it is necessary, and it isn't always necessary. So in other words, I wouldn't go out and start spending money that you don't necessarily need to. And sometimes people do that because they want to respond to what INDOT has done. Just be wary. Talk to an attorney before you do stuff like that. Do not meet in person with right-of-way agents. I already touched on that. Do not make a rush decision. INDOT wants you to make a rush decision. These counties, these cities, they want you to make quick decisions because a quick decision is usually a bad decision. It gives you the more time you can evaluate an offer, have other people set eyes on it and see how good or bad it is. Usually the worse off it is because you can find the details that reveal how bad the offer is. But at the same time, do not ignore this case altogether. I've had folks that they don't want to deal with it, kind of an out of sight, out of mind situation, and they end up in litigation when they shouldn't be in litigation, and now they're stuck. So it happens way more often than I'd like, or than we'd like, but it's certainly something that does happen. So just don't, when it comes, be a little vigilant about it, address it, don't let it lie in the weeds, and then blow up into a worse situation. And I want to talk about now, we talked about what's compensable and what's not, and how can, a lot of people come to me and say, well, they got an appraisal. How bad could this offer be? An appraiser went out and did it. And the reality is that appraiser works for INDOT, and that appraiser wants to keep working for INDOT. And in order to keep working for INDOT, appraisers want to keep their client happy generally, and they want to keep INDOT happy. And what's an easy way to keep INDOT happy? And that's going out and doing appraisals that maybe are less than what the market reveals. So it's important to keep that in mind, that appraisers can differ quite a bit. And just because they have a number that they've come up with doesn't mean you don't yourself have a number much higher than theirs, potentially. So this is what, and these are some pivotal keys to your case. These apply to most cases generally. So I want to touch on some topics of compensation where INDOT might not be sufficient. First of all, the value of the acquisition. What is the underlying land value? What do they offer from a price per acre or a price per square foot basis? Not valuing land is not it. Most people can generally value land. However, this is a little unique because sometimes you can make what's called highest and best use arguments. Highest and best use means that the highest and best use of your property is X or Y. And whatever the highest and best use isn't necessarily what the interim or the current use is. An example of this would be if you have a residence that's in the middle of commercial land. Let's say you have a house, but it's surrounded by commercial property, and it's developed all commercial, and commercial is coming your way as well. The highest and best use of that property might not be residential; it might be commercial. And if that's the case, that can reveal higher land values. Your property is more valued commercially than it is residentially, generally. So that's something to also keep in mind. This value of the acquisition is premised on sales comparables, comparable sales in the general area of the property. And a lot of times appraisers for INDOT will look at the lower comps as opposed to higher comps, or maybe look at all the comps, but only consider the lower ones. So that's something that you're going to need to monitor from the offer. The second component is remainder damage, and this is only for partial takings. And a partial taking, of course, is a taking that only takes a part of your property. There are total takings and partial takings. Total obviously takes all of it. Partial only takes a portion of it. So in partial takings, a common aspect of compensation that is ignored by the condemner is remainder damage. Remainder damage is an umbrella term that we use, that everybody, appraisers use to describe anything that impacts the remainder property because of the partial taking. So an example of this would be for residential properties, setback loss or an ordinance noncompliance. So setback, of course, is the distance from your house to the road. And generally speaking, people prefer their houses be further away from the road than closer to, due to all the things that people don't want to live near. That's noise, sound, safety, etc. And danger, everything that comes with living next to a road, of course. So if they move the road closer to your home, it's possible that your property, your home, would lose value because it's now closer to that thing it wanted to be far away from, that being the road. And sometimes it gets too close to the road such that your house is violating local ordinances. There are very commonly setback requirements in municipalities and other counties that require your house be, let's say, 30 or 40 feet from the road. And if they make your house 20 feet from the road, then not only is your house less valuable because it's closer to the road, but it's also non-compliant with an ordinance requirement, which leads to other complications, devaluation of the property. That's the main, it's the name of the game here with remainder damage. How does the acquisition devalue the rest of the parcel? For commercial properties, partial remainder damage can reveal itself in a lot of different ways: ordinance noncompliance, access, loss of access, visibility. All of these components, reduced parking, change in the highest best use, they all contribute and can contribute to the devaluation of the remnant. So it's important to keep this in mind, because I would say remainder damage is the biggest problem that Indiana appraisers have. INDOT appraisers, condemner appraisers, it's something that they don't recognize, and if they do, they don't recognize to the proper extent. So I keep my eye for that if you have a partial taking. And then finally, relocation. Relocations are for only total takings. So if they're taking a house or a business, you're entitled to relocation benefits in addition to your just compensation. And that is a whole other component. If you have a total taking, I'm happy to talk further about what that means for your property. But the point is that there is an additional amount of compensation that you get when they relocate your business or house. Okay, folks, I am almost to the end. We're talking a little bit more about our firm and how to hire us. Our firm, a lot of people wonder, I have this taking of my property. It's not something I asked for. Do I have to pay an attorney now just to just to make sure I get just compensation. And you do have to pay an attorney, but the way we do things allows you to do it without having to come out of pocket. And the way we do it is through a contingency fee, which a lot of people are familiar with, but a lot of people are not. A contingency fee is a fee premised on how much more we get than what is offered by the condemner. An easy example of this is the example that I provided. Let's say your offer is $10,000 and you hire our firm, we get you $100,000. And in that instance, we would collect a third of the value we add to the case, and that comes out at the end, not at the front. So you don't write the checks in our relationship; we write the checks generally, and it just comes out at the end. So, an example in this scenario, we would write you a check for $100,000 minus our fee at the end. That would be the only money that would go either way. So that's how we do it. It's easy. We feel like it's easy for landowners to hire us in this way. It doesn't require any upfront money, no retainer fee. Again, no money exchanged until the case is resolved. And these are, we talked a lot about our knowledge, but we pride ourselves not only on our knowledge but on our results. We are a results-based firm. These are some examples of our recent results. I want to be clear that I'm not telling you that we're going to get you a $1.45 million or 2.5 or 3 or whatever for your property. These are just the purpose of me showing you these is that the difference in opinion that can exist between the offer and the result. You see, these are all, these initial offers that were issued in these cases, and these are 6 of hundreds. They're all, those offers, those initial offers were premised on appraisals from INDOT or you name it. And, they came out, they appraised it, and they were wrong. In a lot of instances, they were really wrong. And this is, I think, exemplary of how wrong they can be and why it's important to get a full analysis of your case, because you don't know. You might have a lot of money sitting out there that you didn't consider because this isn't what you do all day as your job. So again, at the end of the day, we pride ourselves on results. Knowledge is one thing, but getting clients the proper amount of compensation is our job. So that is pretty much the end of the presentation. I'm going to talk about this slide real quick, and then we'll take questions. If you have questions, please submit them in the chat box or the Q&A box. I'm happy to answer them here once I'm done. So go ahead, and if you have any questions, feel free to answer them. Moving forward, what I would say is if you have an offer, that is time to start seeking out getting an attorney. If you don't have an offer, you're a little early. You don't necessarily need to get an attorney yet because you don't have a case yet. Just sit tight. And, again, I don't know when they're going to come through and make these offers. I don't work for INDOT. They are certainly not going to tell me that information. So I don't know when it's coming. But at some point, we believe that in the next year or so, they'll make an offer. And so once you get that, it's important to start thinking about hiring an attorney. But once you get that offer, again, don't rush into a decision. We talked about that previously. Talk to an attorney, do your due diligence, get a group together. That's an optional thing. That's only if you live amongst a bunch of neighbors and you guys all are close and you all want to be represented by the same attorney. Our firm. If that's the case, it makes it a lot easier for us to do our job, and as a consequence, we can lower our fees if you have a group. Not necessary, but it's something that we throw out in the case that is what you're doing. So and I'll end on this. One chance, this is it. Once you sign the paperwork, it's done. It's over. I've had too many landowners contact me after they've already signed the paperwork and say, well, I'm having second thoughts. I don't think that this is fair. And at that point, it doesn't matter. There's nothing I can do once the ink's dry and you've signed the paperwork. So before you sign anything, talk to somebody. Doesn't matter who. Well, it does matter who. You should talk to somebody who knows what they're talking about. And I'm more than happy to talk to you along with other attorneys at our firm. So, if you're not sure, give us a call. If you are sure, give us a call and we'll confirm what you already thought. We do not charge for case reviews. We do not charge for phone calls and emails. So if you have questions, please don't hesitate. That is our toll-free, rather, that's our local number. And that is my email address. Feel free to answer ask any questions you might have. And with that being said, I see there's some questions being asked, so I'm going to go ahead and see if I can answer them. So the first question I have, the appraisal process appears to be flawed in that there should be two appraisals, one appraisal of existing conditions and one after eminent domain. That way the appraiser is providing a finished value amount. Who decides what this amount is? That's a great question. And I want to clarify. In a eminent domain appraisal, the one that is done by the state or the city or the county pre-suit, is actually three appraisals in one. Because every eminent domain appraisal for a partial taking, I should say, is three appraisals in one appraisal. It is the before value of the property, it is the value of the acquisition, and then is the after value of the property. So what you're describing, the existing conditions and one after eminent domain, is how appraisals are done in an eminent domain context. The before value is the existing conditions, and the after value is after the road's gone in. So it assumes the road goes in for purposes of determining the after value. And that actually is why eminent domain appraisals are more expensive than, your standard bank appraisal or just a mortgage appraisal or just a local appraisal of your property or a HELOC or whatever. Those are just appraisals of the property. They are, what is this property's worth? And it's just one appraisal. But with eminent domain, they're actually, like I said, they're actually three in one, and as a consequence, they're more valuable and they're more expensive, and not every appraiser can do it. A lot of appraisers don't do eminent domain appraisals. They're a special type. So I believe that answers your question. How it works with appraising. The next question, from initial discussion with engineers on the project, they have expressed desire to change drainage flow and use the entire length of my property to install large culverts to handle water flow. Are there additional factors that would play into this type of use? I guess I don't necessarily understand the question. That I guess, is there other things they could use the property for? I mean, ultimately, it's going to come down to what they're buying. Are they buying an easement? Are they buying full fee simple right away? A lot of times with road projects, there'll be a little bit of both. There'll be the acquisition that they need for the road, and then there'll be some ancillary acquisition that they need for drainage, as an example, and they'll get permanent easements. So I guess additional factors, I would say that if you have a residence and they are installing a bunch of culverts up towards the road and the road's coming closer, I think there's an argument you can make that the house is losing some value. It depends really on what it's going to look like, how close your house is to the road, the neighborhood, the area, the type of situation you're dealing with. So that's really going to come down to what the offer looks like and what they're actually acquiring. And then once we understand that, you'll be able to consider all the other factors that come with that type of acquisition. I hope that answered your question. If it didn't, feel free to answer another one or ask another one rather. So another question, I have a fence and high-end landscaping. Am I responsible for restoring these items? I need the fence maintained due to animals. They have to pay for anything they take. They have to pay for any fencing they take. They have to pay for landscaping that they take. So that's part of the acquisition. But that too, will come in a lot of times lower. They'll undervalue fencing. They'll undervalue landscaping. And the fact that you need the fence to be there for animals, that's you might need to negotiate compensation for a temporary fence, that to install while they're in construction or when they are coming in. That's certainly something that you can negotiate and should be part of your negotiation posture. But yes, you get paid for landscape. You should get paid for landscaping and a fence. And trees to a lesser extent, you'll get paid for trees. But the big thing with trees is not necessarily the value of the tree itself. Of course, trees are very valuable, but that's not how trees are valued in the market. But the importance of trees would be the loss of the cover that they provide to the residents a lot of times, or whatever other function they might be serving the trees. Usually, trees supply cover, bushes. They supply cover from the roadway, and if they're taking that landscaping, yes, they have to pay for the landscaping, yes, they have to pay for the trees, but they also have to pay for what the loss of those trees, what the loss of that landscaping means to the house, or whatever we're dealing with. And what does that mean, from cover for the road. Okay. Are there any other questions? Question I got: how much of a difference is there between residential property and the same property that is zoned commercial? Well, I'm going to give you the classic attorney answer, and it depends. Generally speaking, and this is speaking generally, property that is zoned commercial is more valuable than property that's zoned residential, because ultimately, if properties zoned commercially, or ultimately if commercial development is coming in a certain direction, let's say that you have land that is adjacent to, you have two parcels that are adjacent to one another, one zoned residentially, one zoned commercially, and development is coming that direction. It's going to overwhelm the area. It's coming whether you like it or not. It's, McDonald's moving in, all the development that comes in, with a new commercial area. What you'll see, the difference in value between those two parcels would really be the difference in value associated with getting a variance for the residential property to be commercial, because zoning is unpredictable. It comes with its own costs associated with getting the zoning fixed to allow development. So the fact that a commercial property doesn't need to go through that would be more valuable than a residential property that would need to go through it. Now, the difference between those two, that's very difficult to pinpoint. That is a parcel specific analysis. That's the type of appraising that goes in to should go into their appraisal, just like it should go into your appraisal. And if you need one, I should say. And once you get the offer, I can look at it, we can look at it, and we can give a feel and understanding for value. We're not appraisers, but we look at appraisals all day. I've seen a lot. And so while we aren't appraisers, we can identify what's good and what's bad. And that would be part of our analysis, is discussing the zoning of your case. So it's kind of hard to answer without having more information. It's more valuable generally, sometimes significantly more so. And then the next question was a compliment. Thank you. We appreciate it. And we hope not only you learned something, but everyone else learned something as well. That's the point. So I'm glad we accomplished something today. Any other questions? Okay, I am not seeing any other questions. If you think of something later, shoot me an email. Jordan@landownerattorneys.com. I am happy to answer emails that you might have. If you have an offer, absolutely send me it. I'm happy to look at it for free. We're not going to bill you for it. But other than that, we are done. Thank you for stopping by. I appreciate it. If you want to watch this again, we're going to put it on our website, so you'll be able to access it. You're welcome as well. You'll be able to access it on our website and via email as well. So thank you everyone for stopping by. You've been great, and good luck.